SJC-12551, Lane C. Connor v. William P. Benedict.
Mr. Clark, good morning.
Good morning. Please the court. My name is Robert Clark, and I represent the appellant, William Benedict. This matter arises out of a judgment of divorce from the Middlesex Probate and Family Court relating to a marriage of approximately 28 months, now in its 53rd month of litigation. And the marriage was preceded by an undisputed cohabitation of 6 years. Mr. Benedict met Ms. Connor in year 2000. They moved in together in August of 2001 in a home owned by Ms. Connor. Lived together until they separated in approximately March of 2004 when Ms. Connor relocated to Australia in order to address some health concerns. She returned to Massachusetts in late 2005, and at that time the parties agreed that they would resume their relationship and purchased a home together, taking title as joint tenants. Mr. Benedict asked Ms. Connor to marry him, and she refused. The court found, not a specific reason, but found that Ms. Connor had been interested in maintaining her alimony received from her first husband, and also wanted to continue to address her health concerns.
Are you asking us for sort of a categorical rule that if a spouse is receiving alimony from another former spouse, they can't generate additional time for their marriage? Is that a black and white rule for you that if she's receiving alimony from someone else, she can't be in that economic cohabitation arrangement? Is that the rule you want us to adopt?
Essentially, yes. And I should note that Section 48 refers to the judicial discretion to add, for purposes of determining the duration of alimony, add a period of cohabitation if the court finds that the parties' economic marital partnership began during their period of cohabitation.
Can I ask a follow-up question to that then? I mean, given how much work went into the alimony reform law, was this ever, we have more legislative history on this than usual. Was this discussed? Do we have anything we can turn to for guidance on this issue in the history of the Alimony Reform Act?
I did not brief it, but the rationale underlying the rule...
I'm not interested in the rationale. I'm interested in more the history. Do we have any guidance from the legislature on this question at all?
I'm not certain of the answer to that question. I'm sorry.
So you haven't researched it yourself? Okay.
No.
Okay.
Can I ask you, why doesn't the fact that she's receiving, you call it financial bigamy and some colorful terms, but the fact that one spouse is receiving alimony, why doesn't that just go into the mix as to whether or not there was this economic marital partnership? Because here we do have interrelationship of their assets and assets and liabilities. So why wasn't the judge correct in just applying the factors and considering that as just one piece of economic assets that one partner brought to the relationship?
Well, I guess first, with respect to the question of cohabitation, and I know that this court addressed it, the question previously in Duff Carrioris, and referred to the statutory criteria for cohabitation under Section 49D, and those certainly were present. And they also certainly were present during their initial cohabitation between 2001 and 2004.
Which the judge didn't count.
Which he did not, correct. I think the question, therefore, is how to distinguish an economic marital partnership, where in particular the statute states that the court's finding must be that an economic marital partnership came about during the cohabitation. So one must be a subset of the other, and they may not necessarily be inclusive, but they can be exclusive.
So this goes back to your answer to Justice Kafka, that basically when one spouse is receiving alimony, it's over, that they cannot, it's a disqualifier.
I think it should be, and I think also that would be a good policy, particularly in the context, stepping aside from the question of what makes the economic partnership marital in nature, to the transition into the effectiveness of the Alimony Reform Act in general. Obviously, there have been questions of which portions of the act were intended to be retroactive and which have been interpreted as being retroactive, cohabitation provision being one of them. And I guess the reverse question being that if, in a sense, Ms. Connor's entitlement to an expectation of alimony began to vest during the period of cohabitation, whether her former spouse might therefore have a cause of action to recover alimony paid during that time.
Right, but you represent her current spouse, or her,
I represent her second spouse.
You were her second spouse, right? So I mean, you're basically saying that the first spouse has an issue, right?
Well, I think as a matter of general policy and understanding the concept of marriage in particular is that marriage, whether it's been formalized or not, and here it was not, in order to be an economic marital partnership, the marital nature of it must follow the other forms of marriage, one of which has to be mutual exclusivity.
Well, I'm not sure I understand why why the alimony is dispositive. Look, what about the circumstances in which she's on your client's health insurance and the representations that had to be made to be included in the health insurance? One could say that's dispositive. I think they're both important. They're not dispositive.
I think it's certainly relevant, and obviously there were other aspects of their economic partnership. I mean, certainly and
the alimony is relevant, but why is that the be-all and end-all any more than the decision that your client made and represented to the company that he worked for to obtain the insurance?
I think with respect to the health insurance, that was a benefit that was available at the time.
With certain representations.
Subject to certain representations, absolutely. But I also think that one factor that should be dispositive, or at least highly relevant, is the fact that given the option to marry, both at the time when they moved in and the first proposal of marriage was made, and subsequently when the domestic partner benefit was terminated by Mr. Benedict's employer, the proposal continued to be refused.
Can you clarify something for me? And I'm missing this, and I apologize. Your clients, there's a dispute as to whether or not there was an offer to marry in the purposes. But what did the judge find on that factor?
The judge found that shortly after they moved in together, or roughly at the same time, Mr. Benedict had asked Ms. Connor to marry him, gave her a ring, and she had said no. They went forward with their cohabitation anyway, and there was nothing unusual about it.
And I think there was some testimony, and I don't know if the judge credited, I think your client says that she said the reason she did not want to marry is she wanted to continue her alimony, right?
That was not a specific finding that the court made, but the court
that was going to be my
mentioned it
next question, but
in the
the
same
judge,
paragraph.
right? The judge didn't credit that.
He didn't say so explicitly, but contextually, it seems that he found the husband's testimony to that effect to be credible. And in any event, they were not married until February of 2012.
So what if the roles were reversed? What if it was your client who got sick and had to take disability, and the wife who was well and remained at Fidelity and made big money? Same position, because you were receiving alimony from the ex-husband, even though now it goes to your detriment?
If that were the case, yes. And understanding and with all empathy for Ms. Connor's situation, I should note that the court also examined all of the relevant factors under Section 53E for purposes of deviation from the standard duration, and found that it was not in the interest of justice that the court deviate from the statutory duration.
I'm having trouble distinguishing what you're saying. Is it that it was an economic partnership or it wasn't a marital partnership?
Well, certainly there were aspects of economic partnership. I mean, they're obviously, they're unavoidable in any cohabitation, but there needs to be some distinction between the two, and lacking any particular
You're agreeing that
guidance
there
in
was an economic partnership.
There certainly was an economic partnership.
All right, so the question is, what does it mean to be an economic marital partnership?
Yes, that is the fundamental
Doesn't mean
question.
you have to be married, because then it would already count.
I'm sorry?
It doesn't mean you have to be married, does it? It can't mean that.
It does not mean that they actually have to be married, because that is a specific language of the statute. And the question therefore becomes, what exactly is the intended definition that the statute would give to the term economic marital partnership commencing during a period of cohabitation?
Right.
And unfortunately, we find ourselves, or at least I have found myself in this situation, trying to define it in terms of what it is not. Now, going back to Duff Carrioris, I know that the court relied on the Section 49D factors for cohabitation in relation to that determination. With all respect, though, I think under the facts of that case, the decision was relatively easy, since the parties in that case had already been married, moved back in together, and there was to the extent that alimony was still being paid, it was being paid by one of the parties to the marriage to the other. And there was a unitary or closed system to their partnership.
Is this a public policy you want us to adopt?
In a sense, yes, because given the logical, horrible conclusions, it seems.
What's the horrible conclusion? I know you called it bigamy, but so what's the,
Well, to the extent that
financial bigamy? I'm sorry.
I think, well, I don't want to open a can of worms, but in theory, giving too broad a definition to the definition of economic marital partnership, the question then becomes, what benefit would be available to parties who enjoy a long cohabitation and what otherwise would be considered an economic marital partnership, but never marry, as opposed to the ones who enjoy the same conditions and then marry for a very short period, which really was the case here.
How much alimony would it take to be in a bigamous economic relationship?
I don't think that's possible to quantify, although.
So it could be any amount?
I honestly don't believe that there's any way that it would have to be subject to the facts of the particular circumstance. And
So how would we make the rule then?
well, when I was first considering how to brief this issue and how to approach it, I first considered, okay, on one hand, it is a question of first impression, but on the other, it really is a question of last impression, because under current law and with, assuming retroactive applicability of the Alimony Reform Act, in this instance, when the parties moved in together, Ms. Connor's first husband would have been eligible to terminate his alimony payments based on their cohabitation. So I understand that there are, obviously could be a number of cases in which this issue might still arise in sort of a vestigial way, and particularly in the wake of Chin and Doctor and the non-applicability or non-retroactivity of the act with respect to the cohabitation rules under Section 49.
Could I ask one education question? The judge finds the cohabitation creates a much longer period of time for alimony versus the division of assets. Why is that?
I'm not certain about that, and that really leads to the really significant
Not
issue.
based on a particular, it seems odd that we've got a 4-year accumulation of time for alimony and a 2-year accumulation of time for wealth distribution. There's got to be a difference in the statute that's based on, isn't there?
That's definitely a good question, but I would note that in the context of the asset division, although the judge made that finding and made several other findings relevant to determination of the marital estate. He simply made a blanket division on this 55-45 proportion without regard to any premarital assets or even assets that were accumulated following the parties' separation, or in theory, based on some vague language in the judgment, in theory, assets that were accumulated following the divorce.
Before you switch subjects, so you don't have any idea why the judge created a longer period of time for alimony than division of assets?
I am not certain, no.
Okay, and then the second, because I don't want to leave the division of assets, because I've never seen a retirement account broken down like this way. This is your argument that the judge doesn't give, there's not a quadro, there's no explanation of what you're supposed to do with this retirement account, right?
Exactly, and no segregation date. And I think in particular, it appears the judge may have overlooked the fact that Mr. Benedict's defined benefit plan, to which he had stopped, or which had stopped vesting around 1998, is actually a defined benefit plan which can only be divided by way of quadro. And I believe that the same is true with respect to his 401k.
Why didn't you ask the judge to issue a quadro in the trial court?
I was not trial counsel.
Okay. Why didn't trial counsel do that? Isn't that the resolution to this?
It very easily would be, and I think that's really more of a housekeeping matter than anything else. I think the larger question is the specific requirements that should be included in the quadro, and in particular.
But if it falls short, isn't the remedy, hey, tell us what to do? Because the plan administrators have to do something with it.
Absolutely, and trial counsel did file a motion to amend and did not receive any relief.
Wait a second, it's been a while since the divorce judgment entered, and I don't think there was a stay, was there?
There was no stay, but by stipulation of the parties, we have stayed any division of the retirement accounts.
Okay.
Okay, thank you.
Thank you.
Mr. Bellerose.
Good morning. If it please the court, Mark Belrose for Lane Connor. I also represented Ms. Connor during the trial. I find myself revising my script on the basis of your questions today. I'm going to try to address the questions directly first, and then if there are any matters I have not touched upon in response to those questions, I'll try to clean up at the end. But in response to the first question, which I think is the most important question, frankly, is the statute itself. There is no history, and I've done the research, which indicates that anybody involved in the drafting of the statute, and there were some very prominent family law attorneys involved in the drafting of the statute, there was no discussion at all of the impact or the import of someone in this circumstance continuing to receive alimony during a cohabitation period.
Even though, wasn't that a focal point of the Alimony Reform Act, which was that, these sort of, the spouses who were paying were upset that their spouses were in these long-term relationships and not getting married, so they're continuing to pay. Wasn't this a big part of the Alimony Reform Act?
It was part, and that's a part that's been resolved, quite frankly. There is a specific provision, as my brother mentioned, that now provides for cohabitation as well as remarriage as constituting the impetus for cessation of payment of alimony.
So they gave that spouse the ability to go try to modify the alimony based on such a relationship.
Correct.
But they didn't sort of focus on the mirror image of this.
They did not. They did not, as far as I can tell, Your Honor. Also with regard to the statute, I think the question was raised in several forums, and the question was whether or not the statute doesn't already deal with this specific issue. It does in two forms. First, there is the dreaded catch-all phrase, which is the final factor in the determination of whether or not a shared household or a common household was shared, and that permits the judge to review any and all material and relevant factors. And in this case, there was substantial testimony and evidence introduced regarding my client's receipt of alimony from a prior spouse. So rather than glossing it over, the judge took it into significant discretion and made a decision that based upon his reading of the relationship, and I think that's important, the question was also asked, isn't this simply one component rather than the be-all and end-all of the determination?
What do you think the rule should be? Because your client is double dipping in a way. I know it's not double dipping in the way we've talked about it in other cases, but she's getting alimony and sort of accumulating the right to get alimony from someone else at the same time.
I agree with that statement in part. I believe Justice Budd has touched upon this at least tangentially. The question is, for example, and extremes don't always make the best examples, but for example, if my client was receiving $999 per week in child support and a single dollar in alimony for whatever reason, based upon perhaps the sausage making that goes on in probate court, would that simple receipt of $52 per year, as opposed to something less than $52,000 per year, mean that my client could not be considered in a marital relationship or cohabitation relationship with her then spouse?
Judge Budd poses a harder question, but I'm trying to get the simpler one, which is she's actually getting a full alimony ride.
This is the other part of my disagreement, Justice, is that when you say she's getting a payment, it's actually they're receiving a payment. Part of the evolution of their relationship is
Who they're, meaning?
meeting her and Mr. Benedict.
Oh, I understand Mr. Benedict may be benefiting from this. I get that. And he may not have any, he may not be the wrong person here. But your client's also getting sort of a double benefit in the sense that she's, again, accumulating alimony rights while she's already getting alimony rights. It just seems odd to me.
Well, I think there's one way to explain it. There's actually several ways, but the first attempt at explanation I would give is that, as I put it, the sausage making in probate court, there's not always a clear distinction when people are being made to pay alimony and child support in a family law case. My client testified and testified without equivocation that she left a marriage of approximately 5 years. Her son was 2 years old from the prior marriage. And on the basis of that short marriage, she received two components of support, one being child support, which was significantly greater than the alimony component. In most cases, in my experience as a family law practitioner, and this is all I do, is that the majority of cases that don't appear to be an alimony case, but in which alimony is paid, we're really talking about a tax benefit, which is going to disappear shortly. So if a father is paying $750 per week in child support and $250 in alimony, the benefit to him is that he gets to write off that portion of what is essentially child support, but is qualified as alimony because of the differential tax treatment between child support and alimony. So I don't think because it's called alimony, you can necessarily assume that it was intended as spousal support, per se.
Although that's kind of cute on the judge's part. I mean, I understand that may happen, but that isn't the way it's supposed to happen, is it?
Say that again?
That isn't the way it's supposed to be done. Alimony is supposed to be alimony, and child support is supposed to be child support.
I would disagree. The court has the authority, and parties have the authority as well, to have unallocated child support and alimony agreements. And it is just for that specific purpose, recognizing that a man in Mr. Benedict's position, he would have to earn, or actually Ms. Connor's prior husband's position, he would have to earn $1.50 or $1.60 to pay her $1 in child support, whereas if he pays her $1 in alimony, he's paying her $1 in alimony. And he's,
So what do you believe the rule should be? His rule is you can't have these two things going on at the same time. What's your rule about how we consider the fact that you're receiving alimony during this period of time when you're asking to accumulate alimony?
my rule is the statute. The statute specifically says, and once again, it's the dreaded catch-all phrase, that the court has the authority to consider other material and relevant factors. And her receipt of alimony, I believe, is one of those factors. It's not just a hypothetical question about whether or not the judge considered it or not. There are pages of testimony taken from both parties about the evolution of the payment of alimony, when it started, when it stopped, whether there's some question about whether or not Mr. Benedict knew the exact amount, but there's no question that he was aware of it. The parties were able to come up with an agreement as to the proportional contributions to their household expenses. My client was receiving $5 a week in child support and alimony. She certainly couldn't have made that contribution. And more importantly, I think, Justice, is that the parties purchased the home together in 2006. They had a joint deed to that property, but they also filed the joint mortgage application. So there was certainly an exchange of information, and Mr. Benedict could not have been unaware of the alimony, and he certainly was aware of it enough to raise it as an issue at trial.
When did it stop?
Excuse me?
When did it stop?
The alimony stopped in 2011, and in answer to perhaps your follow-up question, Your Honor, there was an attempt to imply that my client had made a decision to have the alimony stop prior to the enactment of the current alimony statute, but the judge discounted that attempt at Mr. Benedict of implying that she had terminated the alimony for that purpose.
And if you could refresh my memory, what did the judge find as far as the purpose of them delaying the marriage with respect to the receipt of alimony?
I believe, Justice Gaziano, that you made the correct observation, is that Mr. Benedict did in fact testify himself that it was his opinion that she didn't want to stop the alimony. It was the alimony award of a lifetime award to that effect. But in fact, the judge referenced his testimony, but I do not believe
I think that was, yeah, he said he testified to
Correct.
this, but then there was no false
The judge's specific findings relative to the delay of marriage primarily had to do with my client's health and her being in a good psychological and physical position to engage in the marriage. She did leave the relationship for approximately a little over a year. She actually left the country to get some unorthodox treatment in Australia. And during those periods of time, getting back to the question, which I think Judge Lowy brought up, is that Mr. Benedict made affirmative decisions to apply for domestic partnership benefits through his employer, HP. He made affirmative decisions to ask to terminate that domestic partnership benefits during my client's absence. And upon her return, he reapplied, and then when they were notified that they were going to lose those benefits because of a change of HP policy, he sent a series of emails asking why they were being treated differentially from a same-sex couple, which is basically the foundation for why HP stopped the payment of the domestic partnership benefits for them.
And down below, you attempted to get the time period pre-Australia included, correct?
We did, and I think if the judge made any errors, and I believe he did, and it's
So is that what was against you?
I believe that the Duff, and I won't mangle the last hyphenated portion of the name, but the Duff case would have given him the authority to include the pre-Australia period. Frankly, it was a decision that my client and I made not to pursue that particular issue, because if she was awarded an additional 12 months of alimony, that would have given, on remand, the judge an opportunity to review the property division as well. My client was looking for an end point as opposed to an expansion of this litigation.
And briefly, can you tell us what happened with this quadro and what should have happened and what do we do with it?
Well, honestly, I don't think it should be before you, Your Justices. I think it's simply an administrative or mechanical fix. There's a clear, despite what my brother says, there's a clear analysis of the evolution of the values of these assets. I don't think there's any question at all. I think it's an unremarkable part of the case, quite frankly, the division. The case law is clear. The court has the ability to look at any and all assets in the marital estate whenever and however acquired, including premarital assets. There's no distinction necessarily between those assets.
You don't find it a little odd? I mean, the judge finds that for division of assets, it's a 4-year marriage, right? I still don't understand why it's a 4-year marriage for division of assets and a 8-year marriage for alimony.
The asset division portion of the statute does not permit the judge to tack on the cohabitation period.
But doesn't he tack on some of it? He tacks on 2 years, doesn't he?
I'm not sure what he did in that respect, quite
No,
frankly.
but that's concerning a little bit. I mean, so they're actually, you're not allowed to tack on anything for division of asset purposes?
Well, that's a slight misstatement. So the court has the authority to go backwards in time. They do not have to take a snapshot of what the parties had at the time of the marriage and simply say,
Well, but one step at a time. So the first part is the judge has to make a determination of how long the marriage is for division of assets, right?
that's a single element of the statutory analysis for an equitable division of the marital assets. That's correct.
But the judge uses a 4-year period and they're only married 2 years.
Correct.
Is that an error?
I think it's a factual error. I don't think the ultimate outcome is an error because there are 15 other elements that he's obliged to review. And so
okay,
he did review all of those.
So, okay, so he decides it's 4 years. He should have decided it was 2 years. Then he takes these retirement plans, most of which is how long a period of time is embraced by the husband's defined benefit plan? He's accumulated that for how many years?
I don't have a specific memory, but it was primarily premarital. There's no question about that. It was not primarily pre-relationship, But once again, the statute and the case law issued by this court does explicitly give the trial court justice the authority to make
You
a
have the authority to do it, but it's supposed to be derived from the whole way you analyze the marriage, right?
Correct. It's one, but once again, it's a single element amongst 15 elements that the judge is required or obliged to look at. So there are other things that the court looks at. The court, I think the primary question in this case is the court has the authority to look at the question of the future opportunity for acquisition of income and assets. And in this case, there's a clear disparity. I think if I had to latch onto one specific element that the judge probably weighted more heavily than others, I think it would be that.
But it's a 2-year marriage for the division of asset purposes, and he takes a retirement benefit and divides that 55-45, right?
I believe that the overall division was 55-45. So that's part of the problem with the decision, is that there's a collective analysis of the division. In most cases, what practitioners are looking to do is the least number of chops. So if we have, I've had cases where people have 15 or 20 different retirement accounts, and there's a proportional division, and what we're trying to analyze is how do we affect the proportional division without chopping each and every asset up into the 55-45 proposition. So once again, one of the errors that I think the judge did make, and it should have been fixed by the trial attorneys, quite frankly, is, how is this supposed to be done? Well, it has to be done by a quadro. There's no question a quadro has to be done. There may be a question about what happens with the accumulation of any fair market value subsequent to the valuation date. I disagree with my brother. There was a valuation date. It was the second day of the trial. The judge chose that.
Doesn't that need to be remanded to figure it out?
I don't believe it does, Your Justice, because I think there's sufficient evidence in support of the other factors that would support this judge's discretion in making that decision.
So just as a practical matter, if we do what you ask us to do, which is just affirm this thing.
Correct.
You're going to go down to you're not going to need to file a motion with the trial court saying, how do I divide up those retirement counts, this date, deal with the valuation. You don't need any guidance from us on that?
Your Honor, I believe that there is an unequivocal agreement that a quadro has to be done in order to affect the division, number one. And number two, the judge was absolutely clear on the date of the division. I think the only question left open, frankly, would be whether or not what happens with any fair market adjustments to the proportional division after the fact. That typically in a quadro, that have to be explained whether or not the party's entitled to any market increase or decrease in value from the date of the valuation.
So wouldn't the trial court judge just need to determine that?
He would. And then, so
That is a remand, isn't it?
that in my estimation, Justice, that's the sole issue that should be remanded. If I could make one last point before the light stops blinking, going back to Justice Lowy's question, there are two cases specifically regarding the affirmation of someone's legal relationship and the estoppel question. Bedard versus Corliss, which was decided by the Mass Appeals Court 82-360, and Poor versus Poor 381 Mass 392, both state unequivocally that if a party asserts his legal right prior to a divorce or other event occurring, he is stopped from attempting to deny the assertion of that right at a later date. Both of those cases involved, well, one involves a Mexican divorce and the other involves a Haitian marriage or vice versa. But in both cases, the party who had been what they thought was a legal marriage and turned out it was not qualified, was not validly entered into, was stopped from arguing that they were not involved in a legal marriage. So I think those two cases are quite explicit on the point that Mr. Benedict cannot come now and say, I wasn't in this cohabitation relationship when he was telling his employer that he was.
If I can go back to one matter which you were discussing with Justice Kafker, is it your position that the statute is absolutely clear that you use the actual marriage date for division of property, or is that something which we would need to discern from a statute which may not be absolutely clear?
My understanding of the case law, Chief Justice, is that the rule of thumb, as they put it in case law, is typically the date of the trial, but that the court has the discretion to determine a different date. And I don't think in this case there's any evidence the judge abused his discretion in determining the date of the trial as the valuation date.
And is that case law pre or post the change in the alimony statute?
you're taxing my memory, Chief Justice, but I believe it's primarily, I believe it's pre.
It was 1996, I think.
That's one of the cases.
One of the cases.
Absolutely
is
correct.
So
1996. So at
why
least
would, if we need to discern what the appropriate length is, why would it make sense for the legislature to say, for purposes of alimony, we're going to examine what the true length of the marriage is in terms of living together and being financially interdependent as married couples would otherwise be, but saying, but for the division of property, we're going to use a different criteria?
My twofold answer to that question is, Chief Justice, I think they do. There's that discretion within the alimony statute right now, the catch-all phrase, and the asset division follows the decision on the alimony. So if an alimony decision is made, then that naturally will affect the asset division. Secondarily, I think you made the correct reference. If a decision is going to be made to change the analysis for the valuation dates, then I think it's something that the legislature should do with all due respect.
But I'd assume that the legislature has already done it. I mean, if it's one thing to say the legislature has done it and we're changing it, which we can't do, but aren't we trying to ascertain the meaning of the statute? Doesn't somebody need to decide what the law is?
It's an interesting question, Your Honor, but I believe, in my opinion, for what it's worth, the case law is already quite explicit about what discretion the judge has. And I think the alimony statute adds an additional component, but it's still within the parameters of the judicial discretion to determine what the valuation date is.
Okay,
I don't think clarification is necessary in this particular instance.
Okay, thank you. And we'll take our morning break.
Thank you all.